everybody. Good evening. I'm Ashley Brown in for Neil Gordon, who has the night off. Welcome to Law Call. It's your chance to get some great advice about the law, and we leave it open tonight because it's anything goes night. We're going to answer your questions about whatever topic you may have. You'll get a chance to call in and have your question answered live on the air. Before we do that, though, let's check out the docket for the next few weeks here on Law Calls. On the 13th, you're going to get a chance to hear about mom and the law. On the 20th, we will talk about being hurt on the job, workman's comp stuff. That's going to be a good one. And then the following week on the 27th, we'll talk about traffic accidents. And certainly all of us have been touched by that. So some good topics coming up here on Law Calls. Tonight, though, I'm joined, of course, from the Vic Hawk Law Firm by who else? Vic Hawk. Vic, how are you?
Great. How about you?
I'm doing very well.
Thank you for filling in.
Tough task tonight, though. Anything goes night. I got an easy job. You got the tough job. Anything goes night. You're leaving it open for the callers.
We really like it when we have anything goes because then it's a little challenge to you.
Yeah. Try to stump you a little bit.
Yeah, it's a lot of fun.
Yeah.
Tonight, like Ashley mentioned, we have anything goes, and I wanted to remind everybody that we have a website, vichawklaw.com, that if you have questions, you can go to that website, and if you want to call into the office, you click on a little button, and we'll try to help you out with any of the problems that you may have, or if you need a referral, we'll help you with that. We are going to bring in tonight a guest from Aiken, South Carolina, a young lawyer that was born and raised in Aiken, South Carolina, graduated from Aiken High School, went off to law school, was a prosecutor for 7 years, and now been in private practice in criminal law and family law for the last 12 years, and that's Brian Katani. Brian.
Hey, Vic, how are you doing tonight?
Doing great, doing great. Can you tell our viewers what influence do children have in the determination of custody?
You know, Vic, people ask me all the time, Brian, how old can my child be before they can make the decision of where they want to go to live? I tell them all the time, well, the older the child, the more the court gives their preference. However, there is no age in South Carolina where the child can ultimately make the entire decision. Of course, a child that's 16 or 17 is going to have more of a say-so than a 12 or 13-year-old, but still the court's going to look at all the factors to determine what's in the best influence of the child in determining who has custody of that child.
Now, when you have that situation, do the judges appoint either guardian ad litems or psychologists to evaluate the children to determine their maturity, to determine why they choose one parent over another?
That's right, Vic. What's the most common thing is going to be that the court's going to appoint a guardian ad litem. That is someone that's going to speak for the child. In South Carolina, we never have the child coming into court to pit mom against dad about who they want to live with. Also, it's not uncommon to have psychologists, counselors, other professionals come in to discuss what's in the best interest of the child. Because again, the overlying context that the court is looking for is what's going to be the best thing for this particular child, mom or dad.
Now, let me ask you one quick question. If I don't know about South Carolina, but I'm pretty sure on the Georgia side, and maybe Vic can allude to this too, it seems like they're really trying to bring the parent back into the child's life. Is that the same in South Carolina? No matter what, just so the parent's not harming the child or anything like that. Is that the case in South Carolina? If the parent has been, let's say, away for 3 years, they come back and they want to be involved in the child's life, do they try to do what they can to bring the family unit back together as best they can, I guess?
That's correct, Ashley. I always tell people that mom and dad, it's important for them to be in the child's life. And even if grandparents or aunts or other family members may have been raising this child, they're always going to make sure that mom or dad has certain rights. And in fact, their rights typically trump those of any third parties.
Well, you can call into the program tonight if you would like to, 803-442-4551, and it's anything goes night. So whatever question you have about the law, you can get some free advice perhaps tonight from our experts, of course. We've got Vic Hawk and we've got Brian Katani, so we'd love to hear from you. Again, 803-442-4551 is the number to call. Vic, go ahead.
Well, I think
you're ready to say something.
Larry has a phone call for us. Yeah.
All right. Larry, go right ahead. You're on Law Call.
Yes, I have a question. Me and my wife, we've been separated from like 8 years, and both of us want to file for uncontested divorce. And I want to know what would be the procedures and how much would it cost?
How much? Do you have children?
Yes, I have 2 kids, sir.
All right. And do you have property, real property and personal property that you own jointly?
No, sir. We don't have nothing joined together. Everything is separate.
All right. Ashley, excuse me, Larry, in that situation, although I don't do divorce work and you should consult a divorce attorney, there are lawyers that just do uncontested divorces. And if you're in agreement concerning the custody issues, visitation issues, property issues, is really very inexpensive. The fight comes and the cost comes when you fight over custody, when you fight over property. And there are many lawyers who handle these uncontested divorces in Georgia. It goes as low as $200. It can be as high as how much you want to fight for. Is it the same, Brian, in South Carolina?
Vic, that is true. Usually if it's truly an uncontested divorce, it usually is a flat fee. It can be relatively inexpensive. However, the important thing, Larry, to remember is you and your spouse may think it's uncontested, but there may be issues there that the two of you haven't thought about. It may be retirement issues or other property issues. So certainly sit down with an attorney, talk about these issues before you make any kind of determination.
All right, well, let's try to take another caller here. Let's go to Jane in Aiken. Jane, you're on Law Call.
Yes. I'm asking about a will that was left in my father's name 21 years ago. When my father passed away, he had left property to my mother and to me, and my mother's property was sold to my ex-in-laws, which I am divorced from my husband, and somehow my mom is incompetent, and they got my mother to sign a paper to sign over my rights of the property that was left in my father's will to me. And I don't understand how they did this. Is this legal or not legal? Or
Brian?
Jane, the first concern I have is when you're talking about your mother signing over something when she was incompetent. Someone who's incompetent cannot legally sign over anything. So that's the first question I have in this case. It sounds like you have a lot of things going on here. I will certainly encourage you to go and sit down with an attorney in South Carolina to really discuss this in more detail.
One that specializes in family law.
That's right.
Yeah.
That's right. Well, thank you for the call, Jane. It's just about time for us to take a time out. I do want to remind you, though, you can call in. It's Anything Goes night, so any question you have for Vic and Brian, give us a call at 803-442-4551 here on Law Call. We'll be back in just a moment.
State. This means that the division of property and debts between the divorcing parties should be fair and equitable, but not necessarily equal. There is no fixed standard to divide property, so each case will be decided on the facts. Generally, property division for a short-term marriage is pretty straightforward. When few or no joint assets have been accumulated, the tendency is to unwind the marriage. This means giving back to the husband and wife what each of them brought to the marriage and then dividing up the assets and debts the parties have accumulated since then. The longer the marriage, however, the more difficult this unwinding may be. For a long-term marriage, judges will typically begin with something like a 50-50 division of the estate. A judge has the freedom to depart from that 50-50 standard, and sometimes fairly dramatically, depending on the circumstances of the divorce. I'm attorney Melissa Detchmindy of the Vic Hawk Law Firm. Back to you.
Thank you very much, Melissa. Back here on Law Call, and you can call into the program if you'd like to. It's Anything Goes night, so any topic is up for grabs. We have a couple of experts standing by to answer your questions at 803-442-4551, and we're going to go ahead and go to the phones and go to Jim. Jim, you're on Law Call.
Yes, sir. Thank you for taking my call. I have 6 felony drug possession charges, 4 from Georgia, 2 from South Carolina from several years ago, all felony. I've completed my sentence, paid all my fines, everything's completely been finished in that regard. I'm now a ministry leader in my church and have resolved all those issues. And I'm hoping to apply for a pardon, and I was wondering if you could help me with any advice about how to go about that, and what do you feel my chances are of actually getting a pardon?
Brian?
Well, Jim, that's a tough question. We have to look to see what your exact charges are. You said they were several years ago. How long ago were these charges? Now, it's wonderful that you're now a minister in your church. That in itself may not be enough for the pardon board. It may have to take a bit more time for you to actually receive that pardon. Again, and the pardon doesn't come off your record. The charges would still be on your record, though your record would state that charge was pardoned. Vic, how would it be handled in Georgia?
Well, Georgia would be a little different. You have certain time periods, 5 to 10 years. You can get expungements after a certain period of time. You have to go through a special procedure where you apply to the Sheriff's Department, local district attorney's office for consent to the expungement. There's an application that you can make to the Board of Pardons and Paroles for clemency, and there's an application you can make to the governor for a pardon. But those are opportunities that you have to clean up your record that you'll have to wait a little while longer, at least 5 to 10 years after the completion of the last probationary period in Georgia.
Don't tell him 5 to 10 years. you might have a flashback.
That's right.
No, I hope everything works out for you, Jim. Thank you for the call. Let's go next to Chanel in North Augusta. Chanel, you're on Law Call.
Hi. My question is, recently, a couple of weeks ago, me and some friends were at a bar, and there was a bar and grill. There was an undercover officer there as well. He wasn't an undercover officer. He was just a captain. With that being said, we were just there having a good time, having some drinks. We weren't too loud. The management didn't come up to us. The bartender didn't come up to us, but he did. And he said that we had said some words that he didn't appreciate, so he called the crew of leaders in, well, the other police officers in, and they gave me a ticket for disorderly conduct, and I was in a public place at a bar and grill. And I just wanted to know, with them giving me the ticket of disorderly conduct, is that legal? I mean, I was placed, and I wasn't being disorderly. I wasn't causing an IRAT issue or a complaint. I mean, I wasn't causing any confusion. So I just want to know, is that against the law for me to be at a bar and grill with friends and family members and then enjoying ourselves without causing any conflict?
Brian, you want to go first?
Thanks, Vic.
Yeah.
Chanel, disorderly conduct is one of the most open-ended laws that we have in South Carolina. You'd be surprised that a lot of things that many of us do all the time technically could fall under disorderly conduct. I tend to agree with you. It looks like they were just trying to come up with a reason to get you out of the bar, and they certainly could have done it better without writing a ticket. Technically, using profane language at a place like a bar where it can be overheard by other people, within the statute, it probably is a per se violation of the law. However, I would definitely recommend you going to talk to someone in South Carolina that does criminal law and go over the details of the case more closely.
Yeah, Vic, is that something disorderly needs to be taken serious because it's still on your record, right?
It is, and it's really tough because, like Brian said, the statute's written so broadly. Basically, if you engage in loud and opprobrious language in a public setting, they could charge you with disorderly conduct. Whether or not it's sufficient to result in a criminal conviction is going to be determined by either a judge or a jury.
There you go. Hope that answered your question, Chanel. I tell you what, we've got a little bit of time. We're going to try to squeeze Frank and Aiken in, people taking advantage of Brian being here tonight. Frank, you're on Law Call. Go right ahead.
Yeah, I was calling to let you up. I gave a guy my truck about back in February a year ago to have a motor. I bought the motor from him, and he was going to take my motor out of my truck and put the other motor in and get it running for me. Well, he's had it since, like I said, since February a year ago, and I can't get him to get it done. And I don't know, I need to go ahead to a magistrate's office or what I need to do. I hate to have to sue the boy.
Yeah.
I
Brian,
don't want to do something like that.
Yeah.
Right. Frank, what I think you need to do is go see the magistrate. First thing I would do is file a claim and delivery. That is, you want to get the actual truck back in your possession. Who knows if the truck is still even there.
All right.
Then
Oh, I'm sorry. Go ahead, Brian.
Okay.
Finish up.
Then if there are damages, you very well may want to sue him for those. So.
There you go. I hope that helped you out, Frank. And we're going to be back with more from our two experts here on Law Call, Vic Hawk and Brian Katonic. We'll be right back after this break. Welcome back tonight, folks. We've had some good calls so far. We're going to keep it going. We've got Tim in Aiken. Tim, you're on Law Call. Go ahead, Tim.
Yes, I was just wondering, when I was 16, I was abused by my mother, and I've had a lot of medical problems that have popped up since he beat me up when I was a kid. Now, can I legally file in court so he can be responsible for, like, my medical stuff, or since it was back in the 80s, I don't know if they had a statute of limitation.
How old are you now, Tim?
40.
40. Brian?
Yeah.
You know, Tim, that would be a very unusual case. I can't say that you would have no right to do this, especially the fact that you were a minor at the time. Though it very well could be a difficult case just to prove the facts that something that happened 20-something years ago that you could sue for damages now. I'm not saying that you can't, but Tim, it could be difficult.
Jim?
Tim, did that help you out? Or at least I hope that helped you out. Now, Vic, when you're tackling, that's a tough subject there, tough task. Yeah. What is something like that even going to cost him, though? Because you got some costs involved.
Yeah, that's really a bad situation when you have a son suing a father. And even in Georgia, the statute of limitations would be 2 years from the point where you reach the age of majority at 18. So since he was 40, I don't really think you would have a claim any further. And also, even if he was a minor at the time and filed the claim, you'd have the problem with interfamily immunity. If it is intentional abuse, then you could probably get around it. But you always have a difficult situation when you try to pursue a family member for money damages in a civil court. The juries don't like it, the judges don't like it, and it's difficult to do.
All right, well, let's continue with the calls now. We're going to go to Jim in South Carolina. Jim, you're on Law Call. Go ahead, Jim.
How you doing tonight?
Doing well.
Doing great.
In July 2005, I was arrested for simple possession of marijuana and false information to a police officer. I was doing some construction work, self-employed, in a small town in South Carolina, and I had an employee with me. And like I said, we were arrested for simple possession and false information to a police officer. We were jailed, and the judge gave us a cash bond where we had to actually pay cash and we couldn't go through a bondsman. This was in 2005, and we went to court and asked for a trial by jury. And actually, we haven't heard anything else from that since then, and July is coming up on 7 years.
Brian? You know what happened in Georgia? What he did was post a cash bond,
right,
and they demanded a jury trial, and it's just never been brought up for trial, according to him, and he hasn't received any notice about it. So what can he do in South Carolina?
Well, in South Carolina, it sounds to me that they're not very interested in going forward with the case. The cash bond is your money. Putting up bond is you're ensuring that you're going to show up when the court case does come up. Now, if the case is still pending, you can't get the money back, but once the case is dismissed, you are entitled to get that money back. Whether you be found guilty or not guilty, that is your money to get back.
And you know, the scary thing about it, I've seen it happen before, is you demand a jury trial and the notice is sent, you've changed the address, but you haven't notified the clerk of court, and they try you in abstention in South Carolina, don't they?
That's right.
So that case very well may be disposed of, and you need to contact that clerk of court to find out what actually occurred with regard to your case.
All right, well, let's go to the phones again. Let's talk to Paula in Augusta. Paula, it's your turn on Law Call.
Hi, Paul. I was going to say hi, Paula. I was nervous.
We're nervous too.
Okay. I'm just curious about the situation. I have a relative that is presently in prison for a capital offense, and he's partial heir to property in Georgia, South Georgia, And not only is he on air, it was entail property, so there are 4 families involved, including him.
Mhm.
I was wondering, this property will be, he has serving a life sentence, so this property would probably be tied up forever. I mean,
Yeah.
nobody can sell it or do it. I just wondered if a felon can sell property, or does the state confiscate it, or what? I'm just curious.
Paula, the answer to your question is real simple. A felon can own property, all kinds of property, personal property, real property, and if it's tied up in an estate, they're going to have the rights as heirs just like anyone else, and you'll have to try to get that person to cooperate with the division of the estate, but they can definitely own property.
All right, well, thank you for being on Law Call with us tonight. I want to thank Brian Katok and, of course, Vic Hawk for being with us tonight, answering all of our questions. We'll be back next week at 11:30 when you can ask more questions and get legal advice right here on Law Call.
Thank y'all very much for calling.
Thank you.
Good job.
Enjoyed it.
I enjoyed it too. Thank you.
Thanks.